The access card reader beeps twice, that little double beat that means denied, not error, and I stood there in the lobby of a building I'd spent 11 years helping build, watching the security display flash red where it had always flashed green. Nobody said anything. The receptionist, Jenna, looked down at her keyboard. The two junior analysts waiting for the elevator suddenly found their phones very interesting. I pressed the card against the reader one more time just to be sure. Red again. I walked back to the front desk. "I think there's a problem with my card," I said. Jenna looked up, and I could see it in her face, not surprise. She already knew. "Mr. Weston," she said quietly, "I've been asked to collect your badge." I handed it to her, didn't say a word, took my coffee from the counter, picked up my laptop bag, and walked out through the glass doors into the February cold of downtown Calgary. The Bow River was frozen solid that morning. My breath made clouds in front of me. I want to explain something before I go further, because the first question everyone asks when I tell this story is the same one. If your algorithm was worth that much, why were you still working there? Fair question. Here's the honest answer. I'm not someone who walks away from things I built. I spent 11 years at Meridian Resource Analytics, first as a senior data scientist, then as chief architect, developing a predictive modeling system that changed how mid-size oil and gas companies managed their reserve forecasting. The algorithm I wrote, which I'd patented in 2011 under my own name as a condition of my original contract, had been licensed exclusively to Meridian since then. It touched every client report, every automated forecast, every regulatory submission the company produced. The patent was mine. The license was theirs. That arrangement had worked fine for a decade. I stayed because I liked the work. I liked my team. And honestly, I believed the founder, a man named Ray Hadley, who'd hired me out of a University of Calgary postdoc in 2012 when he said I'd have a seat at the table for whatever came next. He and I had an understanding, not written down anywhere, which I'll admit was my mistake, but it was real. Ray retired 18 months before any of this happened, and his son Bryce took over. Bryce Hadley was 31 years old. He had an MBA from Ivy, a firm handshake, and a vocabulary built almost entirely out of phrases like transformational pivot, legacy architecture, and talent optimization. He had never written a line of code. He had never run a regression model. He had never, as far as I could tell, read a technical document longer than a 2-page executive summary. What he had was his father's last name and 51% of the shares. The first 6 months were uncomfortable but survivable. Bryce brought in his own people, a chief strategy officer who'd previously worked in fintech branding, an HR director who kept sending calendar invites for culture alignment sessions, and mostly left the technical side alone. I kept my head down. My team kept delivering. Then Meridian started preparing for a public offering. That's when things changed. Bryce had hired an outside advisory firm to assess the company's asset value ahead of the IPO. When that report came back, the licensing agreement attached to my patent was flagged as a risk factor, a significant one. Specifically, the report noted that if the exclusive license were ever revoked or renegotiated, the company's core product offering would be materially compromised. The algorithm wasn't just part of what Meridian sold, it was what Meridian sold, dressed up in different interfaces and client reports. I know this because one of the associates on that advisory team, a young woman named Priya Kellerman, told me over coffee in the building's atrium about 3 weeks before everything blew up. She'd looked uncomfortable bringing it up. "They're going to move to reclassify the IP," she said. "The recommendation is to pursue a work-for-hire argument retroactively. The idea is that your original contract was ambiguous enough to support it." I put my coffee down. The original contract isn't ambiguous. It's 4 pages. The IP clause is half a page. It says what it says. Priya looked at her hands. "I know. I just thought you should know what's coming." I thanked her. I went home that night and read my original contract twice, then called my IP lawyer, a meticulous woman named Sandra Okafor who'd helped me register the patent in the first place. I explained what I'd heard. "Are they serious?" she said. "I think so." There was a pause. "Okay, Let's make sure you're protected. Over the next 10 days, Sandra and I did 3 things. We filed updated documentation with the Canadian Intellectual Property Office confirming the status of the patent and its existing license terms. We reviewed every amendment and addendum that had been signed since 2011. There were 7 of them, and confirmed that none of them altered the fundamental ownership structure. And we inserted a clause into the license agreement that I'd actually had the right to insert since 2019 under a renegotiation provision that Meridian's legal team had apparently never paid close attention to, an automatic license suspension trigger, tied to any formal challenge of patent ownership by the licensee. In plain English, if Meridian ever officially disputed that the patent was mine, the license would suspend automatically within 72 hours. No court order required, no negotiation. The system would simply stop authorizing the software to run on their servers. I sent the updated agreement to Meridian's legal department on a Thursday. Their response arrived the following Monday, a terse email acknowledging receipt, nothing more. The following Thursday, I was called into a meeting. I remember the conference room being cold. They always kept it too cold on that floor. And Bryce was already seated at the head of the table when I walked in. Beside him sat a man I didn't recognize, someone from the advisory firm's legal team and Meridian's in-house counsel, a quiet man named Harold Fitch who'd been with the company for years and who, I noticed, couldn't quite make eye contact with me. Bryce opened a folder. "We've reviewed the situation around the core forecasting IP," he said, in the tone of someone announcing a quarterly budget revision. Legal's position, going forward for the IPO, is that the algorithm developed on company time, using company resources, constitutes a work-for-hire asset under Canadian IP law. We'll be moving to have the patent registration updated accordingly. I looked at Harold. He studied the table. "That position is incorrect," I said. "The algorithm was developed prior to my full-time employment. The original contract explicitly preserves my IP ownership, and every license renewal since 2011 has confirmed that structure. Sandra Okafor is ready to walk your team through the documentation." Bryce closed the folder. "We've anticipated a disagreement on interpretation. That's why we're having this conversation now, to give you a chance to participate in the transition cooperatively." "There's nothing to transition," I said. "The patent is mine." He looked at me with the kind of patience that isn't patience at all, the kind that's really just contempt with better posture. "We're going to need your badge and your building access," he said. "We're restructuring the chief architect role. Your position is being eliminated." I looked at him for a moment. I thought about 11 years. I thought about the team I'd built. I thought about Ray, who was presumably retired somewhere in the Okanagan, unaware that his son was currently trying to steal the foundation of his own company. Then I thought about Clause 7D of the updated license agreement, which had been sitting in Meridian's legal inbox, signed and filed, for exactly 8 days. "Bryce," I said, "before I go, have you read the license agreement, the current version?" He glanced at the lawyer from the advisory firm. "Our legal team is reviewing all relevant documentation." "You might want to specifically look at Section 7D, I said. "The automatic suspension provision. You challenged ownership today officially in a recorded meeting. The clock started when Harold opened that folder." I buttoned my coat, picked up my bag, and walked out. In the elevator, I texted Sandra 2 words. It started. She replied in 30 seconds, monitoring now. Here's what I didn't tell Bryce, because he hadn't asked and I wasn't volunteering. The suspension wasn't instantaneous. It was 72 hours, which meant Meridian had 3 days before anything visibly broke. 3 days during which they'd probably assume I was bluffing, or that their lawyers would find a way around it, or that I'd come back to the table out of financial desperation. What Bryce didn't know about me, what you can't know about someone from a 2-page executive summary, was that I had been living below my means for a decade. My house in Tuscany Hills was paid off. I had no car payments. I had 18 months of living expenses in a TFSA and another 7 figures sitting in a self-directed RRSP that his company had no access to. I had 3 consulting clients I'd kept quietly active on a project basis, all of whom had been asking me for years when I was finally going to go independent. I was not desperate. I was patient. I spent the first day after being fired at Sandra's office on 8th Avenue, reviewing every document, signing authorizations, and making sure the filing trail was airtight. Then I drove home, made dinner, and called my brother in Edmonton. He asked how I was doing. I said I was fine, genuinely, and meant it. That night, around 11:30, my personal phone rang. Unknown number. I let it go to voicemail. The message was from Harold Fitch. "I'm calling from a personal phone," he said. His voice was strained. "This isn't an official communication. I want you to know that I advised against this course of action. What's happening isn't right. I'm sorry." A pause. "I think you should know they're planning to request an emergency injunction first thing tomorrow morning." I called Sandra. She wasn't surprised. "Let them file," she said. "The injunction will take time to process. Our filing with CIPO is already registered. Their work for hire argument has no supporting documentation. There's nothing in any of your contracts that would support it. They're going to be paying Bay Street rates for a losing argument." "How long before the suspension triggers?" "About 36 hours from now." I went to bed. Slept well. The injunction application was filed at 9 the next morning. By 11, Sandra had filed a response. By 2 in the afternoon, the judge's clerk had confirmed the hearing would be scheduled, not immediately granted, scheduled, which meant there would be no emergency relief before the 72-hour window closed. At 6:17 the following morning, the suspension triggered. I know the exact time because Sandra's monitoring system logged it automatically, and she sent me the timestamp with a one-word message, "Done." I made coffee and watched the morning news. There was a feature about the Calgary real estate market and a story about the Flames' upcoming road trip, Normal Thursday. I imagine Meridian's offices were less calm. From what I pieced together later, from Harold, who eventually resigned and was willing to talk, and from 2 other former colleagues who reached out in the weeks afterward, the first sign of trouble was a cascade of error messages that started appearing across the client portal at around 6:30. By 7, the automated forecasting pipeline had stopped producing outputs. By 8, Meridian's largest client, a Calgary-based uni producer with operations across Alberta and Saskatchewan, had called to ask why their quarterly reserve report hadn't generated overnight as scheduled. By 9, Bryce was on the phone with the advisory firm's senior partner, who was on the phone with outside counsel, who was explaining that the emergency injunction had not been granted and would not be heard until the following week, at the earliest. By noon, there were 3 more client calls. 2 of them were from companies with upcoming regulatory submissions to the Alberta energy regulator that depended on Meridian's forecasting outputs. Missing an AER submission deadline carries significant financial penalties, the kind that get the attention of boards, not just management teams. At 2:15 in the afternoon, my phone rang. It was Meridian's chief operating officer, a man named Kevin Strand, who I'd always gotten along with reasonably well. "Is there anything we can do," he said, without preamble, "to resolve this today?" "Not today," I said. "Sandra Okafor is managing all communications on my behalf. You can reach her at her office." "The client situation is becoming." "I understand," I said. "Sandra's number is on the license agreement, the current version." I hung up. What happened over the next 4 days was, I'll admit, more complicated than I'd expected. Not because my position weakened, it didn't, but because the human cost started to become visible in ways that were harder to watch than I'd anticipated. I heard from my former team lead, a genuinely talented engineer named Dalton Rowe, that 2 junior analysts had been told their contracts were under review. One of them was 26 years old and had just put a deposit down on a condo in Marda Loop. I thought about that a lot. I also thought about what Priya had risked by warning me, and about Harold, who'd called from a burner phone at 11:30 at night because he couldn't live with staying silent. I wasn't doing this to hurt those people. I was doing it because Bryce Hadley had stood in a conference room and tried to take something I'd built with a decade of my life, and he'd done it without a moment's hesitation or a single acknowledgement of what that thing actually was. He'd looked at 11 years of my work and seen a liability to be reclassified. That required a response. Sandra called me on day 4. Meridian's legal team has proposed a meeting, she said. New terms. They want to negotiate a settlement. What are they offering? They haven't specified. They're asking for a face-to-face. Fine, I said, but not their offices, neutral ground, and Bryce has to be in the room. We met at a boardroom in Sandra's building on 8th Avenue. Bryce came with 2 lawyers and the chief strategy officer. He looked like he hadn't slept in 3 days, which I found neither satisfying nor particularly troubling, just informative. His lawyers opened with a revised licensing offer, a long-term exclusive license, increased royalty rate, a formal acknowledgement of my patent ownership, and a consulting retainer to maintain ongoing technical oversight. They also, notably, did not mention the work-for-hire position at all. That argument had apparently been quietly retired. I let Sandra handle the numbers. When the royalty rate came up, she pushed back twice. When the retainer terms came up, she pushed back once. When the acknowledgement language came up, she didn't push back at all, because the language they proposed was already what we needed. I spoke once near the end of the meeting. I looked at Bryce directly, probably the first time he'd actually looked at me since I'd walked out of that cold conference room. I want one thing added to the agreement, I said. A formal letter on company letterhead acknowledging my contribution to the foundational technology that the company was built on, addressed to me, signed by the CEO. You. He didn't like it. I could see that. It wasn't the money, it wasn't the license terms, it was the acknowledgement, the one thing his MBA had never taught him to give. His lead lawyer started to say something. Bryce stopped him. Fine, he said. The license was reinstated that afternoon, system access restored, client pipelines restarted within the hour. The AER submissions went out on time, barely, but on time. I drove home through the city at dusk, the Rockies visible to the west in that particular shade of pale gold you only get in a Calgary February when the Chinook is coming in and the temperature is about to do something ridiculous. I put on the radio. The Flames had won the night before. My coffee was still warm from the drive over. 3 weeks later, a letter arrived from CIPO. Not a form letter, an official correspondence acknowledging the patent record update and noting that the technology had been flagged in connection with a federal review of energy sector data infrastructure, with a recommendation that the patent holder be recognized for contributions to Canadian resource management systems. I put the letter in a frame. It's on my wall now, next to a photo of my team from 2019, the year we shipped the version of the algorithm that eventually ended up in Meridian's largest client suite. Bryce is still CEO. I don't know if he learned anything. I suspect he learned that certain contracts should be read more carefully, which is something, I suppose. Ray called me a few months later. He was in Kelowna, not the Okanagan. I'd remembered wrong. I heard what happened, he said. I'm sorry, I should have structured things better before I left. You couldn't have predicted it, I said. No, he agreed, but I should have tried. We talked for about an hour. It was a good conversation. There's a version of this story where I'm the hero who burned everything down and walked away with a check big enough to never think about any of it again. I understand why people want that version. I've read the comments. But the truth is, I didn't want to destroy Meridian. I built part of it. So did Dalton and the other engineers, and Harold Fitch, who'd done the right thing at personal risk and deserved to work somewhere that wouldn't put him in that position again. What I wanted was the thing Bryce had almost taken from me without even realizing it had a name, the record. The documented, official, undeniable record that I had built something real. The patent office letter gave me that. The letter on company letterhead gave me that. The reinstated license with my name on it gave me that. I still consult for 3 clients. I work from home mostly. My RRSP is doing well. Last fall, I taught a course on algorithm design at Mount Royal University, just 1 evening a week, and 2 of those students have already landed positions at companies I respect. Some mornings, I drive past the Meridian building on my way to get coffee. The lights are on. The systems are running. My algorithm is in there somewhere, doing what I built it to do. That's enough. That's actually more than enough. I've thought a lot about what actually protected me that day. And it wasn't anger, it wasn't leverage, it wasn't even the clause itself. It was the decade of quiet decisions I'd made before Bryce ever walked into that conference room. When Sandra and I filed that updated agreement, we weren't reacting. We were prepared. That preparation didn't come from panic or suspicion. It came from something more basic. I knew the value of what I'd built, and I'd made a habit, sometimes inconvenient, sometimes lonely, of doing things properly. Documenting things. Reading the fine print. Not because I expected betrayal, but because that's what you owe the work itself. That's the part nobody talks about. Everyone wants the moment, the champagne, the shutdown system, the lawyer's call at 6 in the morning. But the moment only means something because of what came before it. Every renewal I'd filed, every amendment I'd reviewed, every time I'd said to a colleague, make sure that's in writing. That's what made Clause 7D real instead of theoretical. You can't improvise that kind of foundation on the day you need it. And Harold. I still think about Harold. He called me from a personal phone at 11:30 at night because he couldn't make himself stay quiet. He didn't have to do that. It cost him something. But he'd apparently decided, at some point in his career, that there was a line he wasn't willing to cross regardless of who signed his paycheck. That kind of integrity doesn't announce itself. It just shows up, quietly, when the pressure is real. Bryce had an MBA, a title, and a room full of lawyers. What he didn't have was any genuine understanding of what he was dealing with, the technical depth of the system, the legal structure around it, or the kind of person he'd decided to underestimate. That gap between the confidence and the knowledge is where everything collapsed for him. Intelligence isn't credentials. It's actually understanding the thing in front of you. I think about the younger engineers who've reached out to me since, a few of them after this whole situation became known in the industry. They want to know how to protect themselves. I always tell them the same thing. Document everything. Own your IP from day one, and never assume that a good working relationship makes a contract unnecessary. Not because everyone is Bryce. Most people aren't. But because knowing your rights means you never have to fight from a position of desperation. What got me through wasn't rage. It was the fact that I'd spent 11 years building something real, and I'd been stubborn enough, some people called it difficult, to insist on being recognized for it properly. That stubbornness, the kind that stays quiet and keeps working instead of arguing, turned out to be the most useful thing I had. The algorithm is still running. My name is still on the patent, and somewhere in a frame on my office wall, there's a letter from CIPO that nobody can ever take back. That's what doing things right over a long enough time actually looks like.